Hey everybody, welcome. So we had a tiny bit of a technical glitch and our Open Educational Resources Special Interest Group is going to re-record our first ever CE event. If you were able to join us for that live session, thank you so much for joining us. But if you're watching back the recording, we're so pleased to have you with us today. Joining me in the room is Dr. Maggie Pavone, who is the president of the Open Educational Resources SIG for the Association for Behavior Analysis International, and Ryan Sain, who you will know as one of the creators of Sitecore and also one of our board members. And I'm Veronica Howard. I am the Secretary Treasurer and one of the founding members, and just really pleased to be here. So I'm going to turn it over to Maggie Pavone.
Thank you so much for the lovely introduction. And I am excited that we get to do this again. Hopefully it's at least close to as good as the first time. I think we did a great presentation in March. So I want to just review our original learning objectives. Again, we're the ABAI OER SIG, and this was our first continuing education event. At this time, the recording is not available for CEs, but it is available as an OER that you can use in the ways that we will describe during this event. So our learning objectives are that we hope at the end of this presentation, attendees will discriminate between the 6 Creative Commons licenses and the protections that each of those offer. Everyone will learn how their work can be used by others under each of the CC licenses, to discuss how OERs align with the Professional Ethics and Compliance Code for behavior analysts, and then how to be able to state strategies for how to avoid violating usage rights and staying within that PEC guideline. I guess the last thing I want to mention before we move to the next slide is that for now, we do have a temporary website up at Facebook. So if you want to find us, go to facebook.com/groups/behavior OERSIG. And you should be able to find us. You will have to answer the membership questions to join the group, but they're very simple. So we appreciate y'all following us there until we get our full-fledged website up and running. All right, so let's first talk about a little bit about the OER SIG. If you aren't familiar with our purpose, we built this SIG as a way to provide information about quality, open, or low-cost educational training and research resources in the field of behavior analysis. And we hope that the SIG provides a forum for those creating OERs to collaborate on new projects, reduce individual workload involved in creating and managing OERs, and to recruit some reinforcement for the works produced outside of commercial publication venues. I think some of our housekeeping could probably be skipped since this is the second version of this. But if you want to know how our CEs work in the future, since we do have others coming up, typically we will require you to be here for the entire event. You'll sign in, and then we send out a follow-up survey in which you'll get a couple of questions related to the topic and send it back to us, and then we'll process your CE for that particular event. We do, as all SIGs and all CEs, we require that people maintain online etiquette, so be civil, be open to new opinions, and be respectful. All right, so the shortest possible introduction to the Creative Commons 5Rs and OER. This is actually an OER that we are incorporating into this presentation. So I want to thank David Wiley for putting this together. And I'm going to go ahead and kind of jump in, hide my meeting controls so I can see. So Creative Commons licenses are a way to give a copyright holder a mechanism to provide everyone in the world with permission to engage in a very specific set of activities that are otherwise prohibited under other types of copyright or intellectual property licenses. They also require that the users or those with permission abide by very specific conditions. Creative Commons licenses, all of them, all 6, require the user to provide attribution. What that means is that no matter what CC license that you use, you're going to have to tell others where you found that resource. The other two kind of differences in some of the licenses that we're going to discuss next is that there are three options around the creation and distribution of derivative works. So of changes or kind of taking that OER and doing something different with it. The licenses also provide two options around commercial use. And we'll talk very specifically about what commercial use means in this particular venue. So as I said, attribution. When you see a Creative Commons license with this symbol here, this BY, that means that if you use that resource, you're required to provide attribution to anyone designated by the licensor. So that could be the creator themselves, it could be an organization that the creator belongs to, or any kind of iteration of those things. And you'll see that the BY icon is present in all 6 of the Creative Commons licenses. So the next kind of choice point here is what to do about derivative works. So a derivative work is a new work or a new resource that's based on an existing copyrighted work, but it is sufficiently creative to deserve its own copyright. So a clear example here would be making a book into a movie, right? That's taking a copyrighted work, but making it different in a very significant way. Translating an essay into another language might also be an example. Some non-examples, which would perhaps be considered not sufficiently creative or significant derivatives to count as a derivative work, would be something like correcting small errors in punctuation or spelling, or taking an essay that is currently in a PDF and translating it into an HTML. Those would likely be non-examples of derivative works. So there's 3 options for how to control whether or not someone can or cannot create a derivative work with your OER. The first is not to say anything, okay? So if you don't see any type of extra icon or there's not a mention of derivative works, then the default here is that derivative works can be created and shared. The next option is this share alike designation. So you see, to me, this kind of looks like a circle, an arrow that's going in a circle. That's the share alike icon. And this means that if derivatives are shared, they have to be shared under the same license as the original work. So you can still do it, but you have to make sure that whatever derivative you make is also licensed in the same way as the original copyrighted piece of material. The third option is that equal sign, and that means no derivatives. So this is the probably most conservative of these 3 options. And if you choose the no derivative option, it means that derivatives should not be made and that changes that don't result in derivatives can still be shared. So the ND license does not permit revising or remixing, but it still allows for some of the other things that might be valuable, such as retention, reuse, and redistribution.
And Maggie, can we go back just to clarify for 1 second?
Yes.
So the first one, when you were saying if there's no icon or no other information, number 1, what you mean is like if there's that little CC by person, yeah, and nothing else, then it's just a blanket CC by license. But a CC by license could also be CC by the little person plus share alike, or CC by plus, one of these other things like non-derivatives. And I think I want to bring that up only because if the material has literally no licensing information on it, then you would assume, of course, that it is protected by all rights reserved copyright.
Absolutely. Thank you for clarifying that. So certainly, when we talk about no icon, we mean no share alike and no derivative icon. There should be other icons likely there too, if we're going to continue with creating and sharing those derivative works. The next area for decision making when it comes to OERs is whether or not a commercial use is allowed. So when we talk about commercial use in OERs, we're talking about a use of material that is primarily intended for or directed towards commercial advantage or monetary compensation. I think that leaves a very wide gray area What is commercial advantage? What counts as monetary compensation? However, this definition is written in that intentionally vague way. So it's encouraging us to be over compliant and not to take advantage of those things. Be extremely careful in how we use anything that might result in commercial advantage or monetary compensation. And then commercial use is always defined in terms of how the resource is used and not necessarily in terms of who the user is. So commercial use could still apply if you are a for-profit or a nonprofit. You could still fall under the category of being intended or directed towards commercial advantage or monetary compensation. So again, two options that you'll see in addition to that CC BY license. The first is that you may see this these other types of combinations of CC BY, CC non-derivative, CC share alike, but you might not see this symbol that looks like a money sign being crossed out. In those cases, commercial use would be allowed. If you see that other symbol here is non-commercial, or to me it's like don't make money, it seems very intuitive, that means that commercial use is not allowed. I think this is probably the place where there is a lot of confusion in these licenses, just because of that vague definition of commercial use. Okay, so here is an overview again of the 6 Creative Commons licenses, and you can see how they put those symbols together in various combinations and what that would mean as far as a user or a creator, and what you can do with those things. So again, all licenses, you see all licenses have this little person here and the BY under it, which means that you must attribute the work to its creator or creator organization. But the other combinations give you a whole wide range of things you can do depending on which choices the creator makes.
Maggie, I did a quick question. It's popped up a couple of times. I've seen some people just use a CC license. What's implied when you just use a CC license with no of the other attributes?
So I'm going to defer to Dr. Howard for this one. I have not seen that yet, but I'm sure it happens.
So sometimes what you'll see is like CC and then a series of letters like CC/BY, CC/BY, something like you're kind of seeing here. Mm-hmm. If you see just CC, it could be that the person is trying to communicate that it is shared under a CC license, but it could also mean that it's in the public domain. And sometimes you'll see CC-0. And so that just means, you know, 0 restrictions. You can use it however you like. Was that the direction you were going there, Ryan?
Yeah, I was just wondering what your opinion was, because I've seen it actually recently in the last couple of days. I was like, I've seen that before, and I didn't know what your take was on it. I always respond to CC BY or CC just by itself as a CC BY. Like, to me, it's ethical to go ahead and give credit where you got it from, but it's other than that, it's completely open. That's the way I interpret it, so I'm glad we had basically the same interpretation.
I think that highlights a really beautiful question that we had the first time that we delivered this particular training, which was like, how do you license your own work? You know, which of these licenses do you put on it, and how do you license it? Well, it used to be before 1974, you had to do all this paperwork, you had to file it with a patent office, like the equivalent of a patent office, a copyright office. You don't have to do that anymore. You just have to slap one of these licenses on there. But I think that question highlights the fact that you want to be clear about what you're actually giving people permission to do. So it behooves you to like check out these licenses, ask questions about these licenses from folks who understand it well, and just be clear, because I've not seen just CC, and I could interpret, unless the author tells me more, like on the first page of their document or in a footnote somewhere, that they're sharing this under a CC0 license or a public domain license or a CC BY license, and that's what they're trying to communicate. So maybe I'm just out of the loop.
I think I think you're on the same page I am in terms of interpretation of it.
I think that's one of the great things that I hope comes out of these types of conversations in the SIG and throughout our field is some more clarity and agreement. You know, I think one of the big reasons that people do something that is maybe, you know, not necessarily following the rules or the guidelines is because they're not aware of it. So they kind of come up with their own version. So maybe as we start to talk as a community, this information will become more widespread, and people will make those clarifications more effectively. Not just CC, but CC0 or CC, and then some information about what they really mean by that. So that's a great question. Shall I go ahead and talk about OERs, or was this a point where we made a switch?
No, I say people need to know this.
Yeah, no, I just meant, does someone else want to talk about it? Or do you want me to keep going?
No, I think you present this beautifully.
Okay, so in 2019, we got a nice definition of OERs from UNESCO, and they defined OERs as teaching, learning, and research materials in any medium that reside in the public domain or have been released under an open license that permits no cost access, use, adaptation, and redistribution by others. So that's a pretty dense definition. So the first thing I wanted to throw out there is that we're not just talking about journal articles, right? We're talking about any kind of medium of disseminating information to others. So that could be videos, that could be infographics, that could be podcasts, it could be any sort of modality of teaching, learning, and research materials. And then as we look at what the second part of the definition implies or means, it's really saying that in order to be an OER, you have to meet quite a few freedoms or abilities for your users that not everything does. So again, I think this is one of the big places of confusion in our field, and it was something that I learned just from conversations with Ryan and Dr. Howard, is the idea that there is a big difference between just being open access or just being free and being a true OER. So let's look at what that might look like. So OERs have to allow 5 activities, and it's nice that they've created some ways for us to remember that. So the 5 R's are a shorthand way of remembering the activities that a license has to permit you to engage in with regard to an educational resource for that to actually be a true OER. So let's look at the 5 R's, and this is Sushumna Rao's way of describing them. I think it's really easy to connect to. So if you want your educational resource to be a true open educational resource, or if you want to use an educational resource as an OER, permission for all 5 of these activities has to be explicitly given. So the first is retain, which just means that you can own, make, or control a copy of the resource. In YouTube land, that means I can actually download and keep that, not just the link, but I can keep that video. Could also reuse it, so I can use the resource the way it was presented to me for any purpose, right? So I could even potentially go make money off of it, or I could use it to highlight that it's good or that it's not good. But I can use that resource as much as I would like to. The 5 R's also include revision, which is really fascinating to me. So OERs can be changed. They can be edited, they can be improved, they can be translated to different languages or different forms of communication. I think this one is where we really get to continue to keep OERs relevant and accurate, and as a community we can work together to continue to make them be as useful and accurate as possible. The 4th R is remix. So that means that we can combine one OER with other resources and create something entirely new. As an example, I could use Sitecore videos in my lectures. I could pull in a video, combine it with my own information or my own talking face, and create a new video. We also can redistribute OERs. So that means that I can share either that remixed video or the original video with anybody else that I wanted to share it with or that might benefit from that particular resource. All right, I love color coding, so this is a wonderful, wonderful slide. if you look at the Creative Commons licenses that we just walked through, hopefully you're kind of thinking like, wow, some of these let us do all 5 of those things, but some of them don't. So just because something is under a Creative Commons license doesn't necessarily make it an OER. Now, you can, if you see the places where we have these green check marks, if you see a full column full of green check marks, those 5 check marks are going to tell you that you can do all 5 of these activities, and so it probably is an OER. So we can be pretty confident that our CC BY licensed resources and our CC BY share alike resources are OERs. In the middle 2 columns, you'll see some yellow check marks. The yellow check marks means that in some cases you might be able to do this activity. And so with these 2 licenses, the CC BY non-commercial and the CC BY non-commercial share alike, it could be an OER. Dr. Howard, you had a good example, I think, at this point of why that would be a maybe.
Well, I think if we can, I'm going to actually defer this to Dr. Stain to talk about, because I know that he has very powerful opinions on there about what is an OER, what is not an OER, why you want to share under certain licenses, and we actually don't always agree with one another. So it's not that I'm necessarily creating a trap. I'm just not going to finish that sentence, and I'm going to defer to Dr. Stain to talk about why it is that he defers to particular licenses, but I'm also going to give a rationale for why I sometimes choose not to use that license.
What's hilarious is that over the years, I guess now, is that Veronica is slowly converting me to use that non-commercial license. That's it's a bit of a joke. It's isn't that great? The beauty of OERs, right? You can change people's behavior.
I'm so glad I retained those before you relicensed them. No.
No, and I'm not going to relicense. I mean, what we're getting at here is the non-commercial clause, right? So when in my world, when I create OERs, I choose CC BY, and I might, under circumstances, choose the CC BY SA, the share alike. But typically, I just leave it CC BY, just as wide open as possible. Let people do it if they want with it. If someone wants to go ahead and make money off of it, then more power to them. That's kind of my opinion. There's some risk there, and Veronica has made some very clear points about other organizations just kind of gleaning things from the internet or out of their sources and then just converting those into money-making endeavors. So there's some serious ethical dilemmas that you may run into by just going around and collecting OERs and then putting them into your own package and trying to sell that package. Although if you want to do that from my personal, very narrow perspective in the basement of my house here, I'm okay with that. Because you know what, if somebody's willing to pay you for the work of you going out there and collecting those OERs, then so be it. But there is some risk there that people don't understand that it's available for free, especially when you start getting into low-income communities and educational settings and things. So there's some problems with leaving it without that non-commercial license, like I typically do on stuff. But in general, that's what I do. I choose to just let it go. Just go have fun with it. Do whatever with it. So that's my perspective.
Yeah, and I'm a little bit more guarded than Dr. Stain. So what I'm concerned about is a recent movement, this idea of like OER washing, or some of the strategies that commercial textbook publishers have adopted to remain competitive at a time when OER is making educational materials more affordable. And I can share some of that data if it'd be helpful for folks in the future. But fundamentally, what it comes down to is OERs help students who otherwise would not be well supported. But we see that big commercial publishers are coming in, taking open resources, slapping their branding on them, revising them a little bit, releasing them, calling them OERs when you don't have a lot of these rights provided, and then charging students for them. So that's why I often will choose a very restrictive license. Like I'll choose a CC BY non-commercial share alike. But in conversation with Ryan, I have been loosening up a little bit and opening up a little bit. So we're kind of coming through the middle.
For the sake of discussion, wouldn't that be solved by both of us just choosing a BY SA license? Because if you choose the SA license, no one can then choose a non-commercial license if they redistribute it.
Well, if you choose the BY SA license, you can still charge for it.
Sure. Yeah,
And
I
so
get
the
your point.
difficulty is, right, it's kind of like one of these really wonderful questions that we got the first time we recorded this. So if you find a YouTube video, like,
Mhm.
can you use it? When can you use it? And I know, Ryan, a lot of your videos, the Sitecore videos are on YouTube and they're under an open license, but like,
Sure.
how do you get them out? How do you
Yeah.
retain that video? And the only way
Sure.
that you can do that is to technically violate the terms of service for YouTube, which says that you're not going to download anything. They don't give you a handy dandy download button.
Not anymore.
So if you have a commercial publisher who takes that material and puts it behind a paywall, you should, if it's an OER, if it's a CC BY share alike, you should have the right to download and retain it. But how do you get it out? You may
Sure.
potentially have to violate the terms of service to do so.
Right. Yeah, that's a
I have like
nasty little conundrum.
a very odd question now that I didn't ask the first time. So if we have to go back and edit it out, we can. But so for instance, what would happen if I went to, I'm going to bring up the cowpie videos. You can't stop me. If I want to save a Sitecore video, a particular one, like my favorite cowpie one,
Sure.
even though I can't download it from YouTube, given that it's under the CC BY license, would I be able to screencastify with it playing and create my own OER?
Well, there's a question of what you can do and what you should do.
Yes.
And of course, we as a special interest group would never recommend that people find creative ways to violate YouTube's terms of service.
YouTube's licenses.
I'm unfamiliar with YouTube's terms of service, which is part
You
of
can't
it.
they used to allow downloading early on,
Yeah.
but now they don't. Like they used to have a button for just download for when they had an open license that somebody could download it. That's gone. I think that sucks up a lot of bandwidth on their end, and it has a lot of management issues on their end. So just to stop that, just to stop the spread of problems that are associated with downloading content, they killed it. And I don't remember when that was, but it was a fair amount of time ago. So for you to use a cowboy video and to be completely legal and honor your agreements to YouTube and everything else, you would say, hey, Ryan, can I get a copy of your video? And I can send it to you. Boom. In the sometime near future, when we can afford to put those all into one particular downloadable resource and folder, basically an open folder, we'll put all the videos up in a folder and they just go download them. And then I would provide a link on the YouTube channel for that. But in general, you can't legally get them off of YouTube anymore. So I mark them as open because that's as far as I can. Mark them on that setting. And then, of course, if someone wants a copy, just let me know.
Cool. No, that's great clarification. And of course, with the CC BY, it means that we're probably going to be able to contact that person, right? Because hopefully, if they want us to attribute it, then we know who they are, or we know where they work, something along those lines. So I did want to come back and just touch on the last two columns here, because when we are talking about that CC BY non-derivative, even with or without the non-commercial designation, just as we just said, that means that we can't revise and remix it. So you can't, you certainly would not be able to call that an OER. Not that it's not still a useful license in certain roles or ways of distributing your information, but do know if you choose these licenses, they would not count as OERs.
A lot of people just want to protect their own content. They don't want somebody to revise their phrasing or chop them up and reverse them around and do something wonky with their words. I get it, but it's just not an OER.
Which I think is, I think that's the piece that I connect to is, we've seen lots of examples of media being revised in ways that represents the original source inaccurately and maybe even in a damaging way. Perhaps not in our field, but certainly just in general media, deep fakes and things like that, where technically they could have taken my face from my open educational resource and maybe say something else. And if it's an OER, then I don't really have control over that. Whereas if I really wanted to protect myself from something like that, I might not be able to use an open educational resource type license. So this again just highlights kind of those differences that we talked about on the last slide. The first two, the CC BY and the CC BY share alike, certainly are OERs, and it's safe to use these in other OER works, so in creating other OERs. The next two are a maybe, and I think that if you choose to kind of pick something that's a maybe, you want to ask yourself, what are the odds that the licensor will interpret your use as commercial? And are you willing to take that risk? We are going to talk about why we are obligated to stay within our usage rights. So, are you willing to kind of gray area your ethics code? I think a lot of us are hopefully not. So, I like the idea that Dr. Howard said, or Dr. Stain said that, maybe you just contact that person and you ask them, hey, do you think that this is an appropriate use for this work? But otherwise, you should be aware that you're taking a pretty great risk, I would say, at that point. And then obviously with our no derivative licenses, even though they are Creative Commons licenses, they are not OERs, and we certainly cannot use them ethically in our OER work.
And a lot of those conversations, like uncertainty around those conversations, can be alleviated just by beginning a dialogue with the creator. So if you're uncertain how they're going to interpret your use of the material, tell them in advance. Oh, and we're switching. Okay. So I think this is the point at which we start talking about the professional and ethical compliance code and the obligations that we have when we're talking about those usage rights on our material. Now note that this particular portion of our presentation does hold that CC BY non-commercial share alike license, as I mentioned, that I often use. Again, just because I like to, as much as possible, protect the content and make sure that it won't necessarily be used for nefarious profit. But that's a personal concern that isn't necessarily shared by everyone. This is just an example of some of that material. Now, when we're talking about copyright, remember that our professional and ethical compliance code requires that we do honor intellectual property. So the PECC section 8.02 highlights the intellectual property obligations that we have. We have to obtain permission to use trademark or copyrighted materials as required by law. And that includes many of the things that we're already doing by good practice, like providing citations or including copyright symbols on material when we are recognizing and honoring the intellectual property of others. We also make sure that we give appropriate credit to authors when we're delivering lectures or workshops or other presentations, when we're highlighting the ideas that others have come up with. This is just standard good practice for being a scientist. But I would like to highlight a couple of things where the ethical and professional compliance code feels a little bit lax. First of all, this is written from the perspective of a very dichotomous black and white perspective. It's either copywritten or it's not copywritten. And there's nothing in the middle, like we're talking about with these Creative Commons licenses, where some but not all rights are shared. The second concern that we have here is that we're talking about making sure that we provide that intellectual property. We're honoring those ideas. We can do that in a few different ways, and it doesn't really give us any guidance on what to do best. So it doesn't incorporate any of those shared permissions that those Creative Commons licenses that we talked about this morning refer to. Now, moving forward, just a super quick note, like we mentioned before, that prior to 1976, all materials had to be registered to enjoy those copyright protections. So anything that wasn't registered before 1976 just fell into the public domain. It meant that no rights were reserved. You could do whatever you want with it. But since 1976, since this U.S. Copyright Act of 1976, anything that's created is assumed by default to be protected under copyright. And that was just one way of kind of equalizing protections and making sure that you didn't actually have to be a copyright lawyer to enjoy those protections for the law. And it really wasn't until we had the rise of those Creative Commons licenses that have some of that variability in sharing permissions that we started to have ways of protecting the material, but also being a little bit more open with it. So traditional copyright, all rights reserved, everything is protected. You have to have permission. You may need to license, like specifically sub-license with the copyright holder. Some of the Creative Commons licenses are referred to as copy left, right? It's just being like a fun play on copyright. So what I want you to take away from here is, if it doesn't indicate, if the material does not indicate what the usage rights are, assume it's all rights reserved. And again, just an invitation to have a conversation with the copyright holder. From here, I hear people talk a lot about fair use, and I hear a lot of misconceptions about fair use, and I can post a really lovely resource of a copyright lawyer just like pulling his hair out of the misconceptions that people have around that term. But when we talk about fair use, it is actually part of a larger expression. It's fair use exemption from copyright. Right? So it talks about the 4 factors and under what circumstances you can use the material. Fair use is determined on a case-by-case basis. They do look at 4 major characteristics, like the purpose of your work, the nature of your work, the amount that you're using, the effect that it's going to have on the copyright market. But fair use, there's no formula for that. There's no black and white. All of copyright law is very gray. So when you hear people talking about, well, I can use it because it's fair, you got to protect yourself, and I would encourage folks to actually use a fair use assessment checklist to see if what they're doing really is defensible under the law. Just a super quick review of those fair use exemptions, like the characteristics that we look for, the purpose and character of the use. If what you're doing is transformative in some way, you get a little bit more protection. If what you're using is for instance, a nonprofit educational purpose, you might get more protection from prosecution if you are found to be violating someone's copyright. But again, no hard and fast rule. The nature of the copyrighted work, creative materials tend to be protected quite a bit more than factual works. So anything that is creative or unpublished is likely going to get much more protection than something that is factually based. The amount and substantiality. And I think that's where a lot of those misconceptions come from, like the 10% rule, which is a complete myth. Ignore that. But the amount would be like, what proportion of the work are you sharing? But then there's the substantiality, which is, are you sharing the heart of the work? And I don't want to spoil anything, but you'll remember there was a children's series of books about wizards in schools, where in one particular book, someone, so if all I tweeted was, this person dies on page 352, well, that's the substantiality of the whole work. You just gave away its huge spoiler. And so you're probably less protected in the fair use exemptions to copyright. And then they also look at what effect could your reuse have on the potential market or value for the copyright. Now, I can all day long as a professor say, you know what, I'm going to give this textbook to my students for free because I just happen to have a copy. Don't ask me how I got it. But if I'm depriving the copyright holder of, $100,000 every semester from that book, I am definitely having a huge impact on the potential market value. And I probably shouldn't do that, right? I'm not going to have a leg to stand on under fair use. So just get permission. This is definitely one of those places where it comes to ask for permission first, not forgiveness. There is no hard and fast rule when it comes to fair use. And the best example of this is something that we all do. It's sharing published research articles with peers. In this case, the American Geophysical Union versus Texaco, we had a situation where members of this reading group shared copies of articles with peers, and they had a reading group. The copyright holder found out about it, brought suit, and they settled out of court because it sounded like it wasn't going to go in favor of the folks who were using those copyrighted published articles in their reading group. So this is a place where this whole situation could have been resolved just by going to the copyright holder, asking permission, or going about it under a more appropriate licensing permission. Just asking for permission, essentially. And typically when you approach the author, when you approach the license holder, they tend to be very amenable to having that conversation about using that material. Ryan, you've published, Maggie, you've published. If people come to you and they want to use your published article to have a reading group with students, are you going to say no?
I say, yay, please.
I'm just so happy that anyone, yeah, I'm just so happy when people are actually reading my work that I'm like, yes, please. Because, we tend to be very giving folks, especially in science, because we know that's the way you move things forward. So please just ask for permission and don't assume that you're protected under fair use. And here's a sample of a letter that I have shared with others before. So this would be a great place if you wanted to have a model. Just stop here, take a screenshot. This was a sample permission letter that I actually sent to someone who had some infographics that actually what they were sharing was something that didn't include citations. So I wanted to use it as a non-example. And they were kind enough not only to let me use that as an example, but they also said, oh, you're right, let us go back and put in those citations so that we are honoring the intellectual property of the folks that we are creating the infographic from. So I was really pleased for that turnaround. So this is something that we're already doing, but don't forget, always, 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 always cite. Always cite, because it's someone's intellectual property and you know that they've worked dozens, if not hundreds of hours on that. So give credit, honor that person's intellectual property right. We also have, I think, an ethical obligation to communicate to others, to be very clear about what our expectations are for others when they're using our materials. So get into the habit, if you can, of including whatever your license is. It could be all rights reserved, it could be a Creative Commons license, whatever it is, just communicate it clearly to decrease misunderstanding around that. And then finally, please do consider a Creative Commons license so that people understand how those materials can be redistributed. Because remember, since 1976, anything without licensing information is copywritten, right? It's protected under copyright law. So if you are taking a worksheet from a website and redistributing it, you could be violating the copyright holder's rights. So communicate clearly on your material, on your website, wherever, how you want your material to be used. And I think, yeah, we did have a couple of questions from the first time around. And they weren't necessarily these questions. So if it's okay, maybe we stop the screen share now and just cover some of the questions.
Sure, absolutely. Oh, I think, sorry, I'm trying to control, and so are you.
Okay, there we go. So some of the questions that we had from the first time around, I've put them in the chat, and I'll repaste them here just in case you joined a little bit late. A lot of them had to do with things like, okay, so I can find this material on YouTube. Does that mean that I can just like use it?
Yeah, that's an issue, right? Again, getting it and getting a copy is different than just playing it, right? You cannot take something that is marked as a standard YouTube license and do anything with it other than watch it on YouTube. There's some fair use issues. You're going to do that in front of a classroom. My guess is you'd be okay. You're going to do that and charge people to access the videos that you so chose to watch on YouTube this week and have a watching session. I don't believe that's legal, because again, you've got a copyright issue there. And YouTube does that anyway. So again, it depends on what you do and how you do it with the actual content. But if it's an open source and it's marked as open, and that is a YouTube license that you get, and you can see it, it's right at the bottom. It says license. It's listed on every video, and it tells you right next to that what type of video it is. It's standard YouTube or open access or open license. Open educational, like is what they say. So that's really it. And then if you want to get a copy, you can't download it anymore, but just contact the person that created it. And there's ways to contact them directly through YouTube. You can just click, you can post chats, you can message them directly, all sorts of stuff.
And so I think what I'm hearing you're saying is if it's got that standard license, don't assume anything. I mean, you can watch whatever you like if you're connected to the internet. Yeah. Do what you like. Check your YouTube terms of service. Right? If you're not intimately familiar with those licenses, you might want to get hip to that. Just pull up a chair and
even incorporate.
That sounds like a blast.
But even incorporating them as part of it, 5,000 pages as a creator, it's even even deeper.
When like a South Park episode is making.
It is, and then even using those as part of a corporate training, like incorporating videos into a training that you're getting paid to use, that's starting to get wonky, and it is not absolutely crystal clear. So caution, soon copyright. Ask permission first is always a good idea.
Yeah, and I think that is related to the next question that we received in the first time around. So if it's posted on YouTube under a standard YouTube license, can we use it openly without checking in with the creator?
I'm not a copyright lawyer. Refer to YouTube. So, like, this is one of those things that's really hard for all of us to answer these types of questions because we're not copyright lawyers. We are, we're people that have a passion for OERs, and there are ways to do fair use. But it's what you're doing with that and how you're doing it. And again, if it's an open educational license on there, then you have a little bit more freedoms, a little bit more less concern, so to speak, if you're using that to teach somebody at your office or maybe a group RBTs, or you've incorporated that into some training that you're getting paid for. But if it's not that, I would be immediately in touch with YouTube.
Well, there's a lot of, you're right. There's a lot of questions about, is what I'm doing right? Is what I'm doing appropriate? And no one person can answer those questions because, one, we're not lawyers. It's not our scope of competence. Two, copyright law is not black and white, right? So the best thing you can do, the best first rule you can ever do, is contact the copyright holder. Tell them, this is what I'd like to do. May I do that? Can I have your permission to use your material in this way? Keep that written material. And if someone comes back, you'd be like, but they said on this date at this time that it was okay. That is itself some of the best protection you can have.
I think too, like, just to highlight the benefit of engaging in that behavior of asking, usually if you're asking for permission, it's because you have an interest in that area of whatever work it is, right? So, if you're checking in with the creator and opening a dialogue about a topic that you both have an interest in, they may have other resources to share with you as well. So you may get more out of asking than just permission to use it. You may get permission to use it plus, right? Or the deluxe permission, where you get additional sources to make your training or your educational event even more robust.
Yeah, beautifully stated. So related to that, the questions of like, how do you find out what license is assigned to the work that you're finding online?
I think we can look for the symbol, but then what happens if we don't see it? Right?
Broken
we
record.
Yeah, I think we touched on that. Or if we don't see it, let's ask and let's assume that we're not able to do these things.
Yeah, because if you don't see it, you have to assume all rights reserved. And so then, have that conversation, have that dialogue.
I guess unless it says created in 1974. Then you
but even that is not
not
because
enough.
then you could, right? Because you could have licensed it after the fact. There are certain works, for instance, like, I'm so sorry. Now we've gone into the territory of me being a big nerd, like the Diary of Anne Frank. There's a variety of different versions, all of which are still licensed and continue to be licensed because the revenue generated helps support that nonprofit organization's work. So you can continue to maintain a license even after a particular standard of time has elapsed or whatever. You can't just assume. That's the thing.
Great point. It's a great point.
And then the last question, this has inspired me. Maybe we need to have a workshop of like, how do you license? Like, what do you need to do to license your work as open? Do we have like a short answer for that?
Put a little logo on it. Go to, I can't remember the Creative Commons.
Pop a little boop on it. Yeah,
pop a little thing. Like, that's it. You could even type the words. I license this as a Creative Commons license. It doesn't necessarily have to be the logo. You could just type it. I've seen some recent resources that we were looking up that were created, probably 20 years ago. And they said, I'm creating this as an open resource that can be used but not modified. That's pretty darn close to what we need. So it's just putting it on there, tagging it somehow.
Yeah, communicating with your user.
And I think I just want to add on that a little bit. I think there's a value too in giving a description. You can certainly just slap it on and hope that everybody knows what that means. But as we have seen, and I'm a perfect example, it doesn't necessarily mean that it's understood that way. And so the more clear instruction and description that you can give of what you really are allowing somebody to do with your work, I think the better, especially if you're a creator.
And I'm so pleased that we cited some of the work by David Wiley. He continues to do research on people's perceptions and understanding of these licenses, and has found that a lot of folks, even those who've been trained in Creative Commons licenses, misunderstand what certain licensing bits are, especially around the non-commercial and the non-derivatives. And then the last comment was from someone who was actually living outside the US. So this is the moment where we take a second just to acknowledge the fact that everything that we've said so far is heavily, heavily informed by US copyright law. So if you're outside of the US, of course, you want to make some good friends with folks in your country who understand this. There's no one better than this, better at this than librarians. Librarians understand this really, really well. And if you are in another country like Canada, reach out. I'm confident we know some Canadian librarians who are pro OER who can talk to you about the licensing requirements in your particular country. Just let us know. But that's it for our questions.
All right. Well, this was just as good the second time as the first time, just as enjoyable. Always lovely to see your wonderful faces. And I think that there's a lot of people that are excited to hear this presentation. So thank you guys for making time.
Thank you for taking the opportunity.
And I apologize for not hitting record the first time.
Oh,
We will shame you forever.
Technical difficulty was not small. It was Ryan's technical difficulty. I didn't hit the button, I guess. Sorry.
Well, I'm feeling really good about this time. So knock on wood, we'll have a video to share with folks. And
we
if
got
people are
IOA
watching
times
it,
3.
Yeah.
We all see it.
All right. Well, thank you guys so much for joining us. And if you
Have a great rest of the
guys have any
afternoon.
questions, of course, let us know. But thank you for joining us, and we'll see you later.
Take care.
Bye.